So, welcome to the second class dedicated to civil liability and artificial intelligence. With this second class, we'll dive into the details of the current and emerging European regulatory framework. So, very much is happening in this domain, and it's fundamental for anyone interested in developing technologies or bringing them to the market to understand what regulatory framework you have to take into account and deal with. So, the first topic we will address is the Product Liability Directive. Because AI systems and machines, advanced technologies altogether are to be deemed products, we will discuss the existing regulatory framework, the so-called Product Liability Directive, which represents the most relevant piece of legislation applicable today to all sorts of advanced technologies, including AI and advanced robotics. Then we'll point at some of the limits of this piece of legislation that also led the European Commission to consider revising this entire field, integrating this entire field, and that will lead us to discuss some of the current proposals that are expected to enter into force within a few months' time. In particular, the reform of the Product Liability Directive and a dedicated piece of legislation, the AI Liability Directive. We will then conclude assessing more or less and mapping the potential risks for anybody interested in developing applications, using applications, or bringing products or applications that are based on AI and advanced technologies to the market that you will be facing if you take into account the existing and emerging regulatory framework. But let's start first with the Product Liability Directive. The Product Liability Directive is a very important piece of legislation that was enacted in 1985. The rationale behind it is that a producer shall be held responsible for all the damage caused by his products when they're brought to the market and they are deemed defective. The legal rationale behind it is the one whereby if you gain from undergoing a given activity, if you take advantage of a specific activity or practice or enterprise, you should also bear the economic negative consequences that are associated to it. So if by bringing your product to the market for profit and selling it to users, not necessarily consumers, you make profits, you should also internalize the costs in terms of damages that you cause to those that using your product get hurt. However, because we know that nonetheless, even with such a rule, some accidents will occur, the second element of this piece of legislation is that of favoring the victim, so helping the claimant obtain compensation. How so? By simplifying the liability rule. So by replacing the traditional fault-based liability rule with an objective standard of liability. So the claimant, the victim, will only have to demonstrate the existence of a damage, the existence of a defect in the good, and a causal nexus between that defect and the damage suffered. Once that is established, liability will follow without the need to establish the fault of the agent, in this case, the producer. So this is the reason why the Product Liability Directive is deemed an objective standard of liability. The rationale is to provide ex-ante incentives to manufacturers to make products safe, to invest in safety, because otherwise they are aware they will be sued and they'll be called in to compensate the damage that they give rise to, and at the same time ease the position of the victim in achieving compensation. But let's briefly go through this piece of legislation to kind of try and understand a little bit better what it actually says. So, Article 1 of the Product Liability Directive says the producer shall be liable for damage caused by defect in his product, which is the principle that I have just explained. And Article 2 clarifies that for the purpose of the directive, product means all movables, even though incorporate into another movable or into an immovable, including electricity. This article is very problematic in the sense that it's very broad and all-encompassing, and this gives rise to some concerns, but doubts or emerged in most jurisdictions whether software could be deemed a product, and this is of essential relevance for advanced technologies. And this is one of the aspects that the European Commission is currently trying to reform, but we'll get back to that. Producer is the manufacturer of the finished product or of any raw material or component, but it could be also, but also the supplier or the importer could be held responsible if the producer cannot be identified. The rationale is if you label something as your product, even if you bought components from somebody else, you'll be responsible as the producer of the final product, even of the malfunctioning and the defectiveness of the components that you have used in your final application that you sold on your market under your label, under your brand. Article 4 is the one that establishes the articulation of the burden of proof, meaning that what each party needs to demonstrate, and it clarifies that the injured party should only demonstrate the existence of damage, of defect, and of the causal relationship between the two. Article 6 defines defectiveness and says that a product is defective if it fails to provide the safety which a reasonable person is entitled to expect, in taking into account the presentation of a product, the use to which it could reasonably be expected that the product would be put, and the time when the product was put into circulation. This is very relevant. At times, even potential foreseeable misuses are taken into account, meaning the typical use of a chair is that of sitting onto it. However, we're all accustomed to using chairs also to stand on them and reach for an object that is otherwise out of our own reach. Standing on a chair is typically a foreseeable misuse of a chair. Now, unless the chair is a clearly fragile or a particular fragile element of decoration, and we could expect to be able to stand on top of a chair without it breaking. And so the foreseeable misuse of standing onto the chair rather than sitting onto it should be anticipated by the manufacturer of the chair and taken into account in the design of its own chair to make it safe, even when somebody stands upon it. However, the producer is indeed objectively liable, but is granted some defenses. Now, we do not have time to go through all the defenses in details, but the most important defenses presented among those presented at Article 7 is the one presented at Article 7, letter D and E. The defense presented by Article 7, letter D can easily be misinterpreted and needs therefore to be clarified. The manufacturer can exclude his liability even if it's already established that the product is indeed defective and that it did cause the harm that the user suffered, so long as he can demonstrate that he designed or conceived his product that way to comply with mandatory existing legislation. This does not mean that the product was certified as safe. It's an entirely different thing. This would be the case where, for instance, you as a manufacturer are required to use a specific product, component, chemical, because the law requires you to use that one component, product, or chemical and not something else. And later on, it is found that it is indeed that component or chemical that causes the product to be dangerous and therefore defective. Letter E, instead, is the so-called development risk defense, which is even more relevant. The development risk defense excludes the liability of the manufacturer so long as you can demonstrate that the state of scientific and technological knowledge would not have allowed you to develop your system otherwise in a more safe way. What does that mean? Because technological development occurs all the time, it is certain that after some years, something that would have been deemed safe can no longer be considered safe because, or as safe because technology evolved and improved. So for instance, a car from 20 years ago would probably no longer be considered as safe as a more modern model because technology simply evolved, and braking system, steering system, and sorts of safeties are now embedded that 20 or 30 years ago would not be conceivable. But for that very reason, you cannot consider a car that was designed and developed 30 years ago as defective for the sole reason that current cars are safer than that one. If you think well this norm through, it's as if Article 7 letter E was introducing back into the system an element of negligence or fault, meaning that the manufacturer will not be held responsible if he cannot be held at fault for the way he designed the system, because there was no way he could have done any better than he did. So it's somewhat like the system reintroduced a standard of negligence within a liability rule that should theoretically be objective, and in fact some lawyers deem this system as a semi-objective form of liability, but that exceeds the purposes of the current analysis. Now, the fundamental question is, does this piece of legislation work? Is it fit for purpose? What emerged in a study that was conducted by the European Commission, taking into account 25 member states in a period of time that goes between 2000 and 2016, is that indeed quite a limited number of claims were brought and successfully litigated based on these norms. If you consider, they found altogether 547 cases. If you consider 25 member states and a 16-year period of time, 547 cases are a very little number. Imagine that the Corte di Cassazione, which is the highest court in Italy, the third level of jurisdiction, will decide something like 30,000 cases in civil law matters per year. So a ridiculous amount. So 547 cases is a very limited number of cases litigated applying those sets of norms. And the vast majority had to do with raw materials, which are typically not too sophisticated and technologically complex, pharmaceutical products, which are instead quite complex in a technological perspective, but which give rise to very relevant concerns, because when there is a problem with a pharmaceutical product, it impinges upon the bodily integrity, health, or life of an individual, and therefore triggers emotional reactions as well as gives rise to really relevant in an economic perspective, damages, and therefore provides very strong incentives to suing the manufacturer who is potentially responsible for such harm. All other cases are very limited. So indeed, we observe a very much clustering in domains that have nothing to do or are not directly involved with technology. And this is something that led the European Commission to thinking that this piece of legislation is not fully fit for purpose and something needs to be done. Moreover, still pursuant to this study that was commissioned by the European Commission in 2018, a vast majority of the claims brought under pro-liability were actually decided applying different pieces of legislation, which are the general rules of contract law and the general rules of tort law in over 89% of cases, which leads us to thinking that after all, this piece of legislation wasn't so effective and wasn't working so well as theoretically it should have, based on the very reading of its norms. But moreover, there were very relevant concerns, very major concerns in the field of advanced technologies due to the doubts, the specific doubts that the pro-liability directive triggered. The first one being the question that I have already anticipated: is software indeed a product? Courts had decided over the years in different ways, and some had found that if the software was installed into a physical support, like a DVD or something, then it would be considered a product. Whereas if it was, let's say, on the cloud, it would not be deemed a product. But this distinction makes no sense, because nowadays all software is just in the cloud and eventually it's downloaded. But this descriptive criteria based on the existence of a solid piece of material on which the software ought to be installed does not really make sense in the perspective of the directive and on what is that and on the interest that it intends to protect. So the Commission felt that something needed to be done in order to clarify that all software is and could be deemed a product for the purposes of the application of the Product Liability Directive. The second issue that emerged in numerous debates is whether the development risk defense that I clarified to you just a moment ago, Article 7, letter E, does make sense, whether it should apply in particular to learning machines that are capable of modifying their functioning over time. So can we apply the development risk defense to learning machines? And moreover, when we discuss advanced technologies, it is most commonly the case that multiple parties could be potentially responsible. So let's provide an example. If we take into account the scenario of the use of a driverless car, we can easily expect there to be, well, let's say the basic crash of two vehicles, one against the other. For each vehicle, we'll have a driver who could be potentially responsible. Because vehicles will not be fully autonomous for a very long period of time. So a partially autonomous vehicle will still have a driver who might be responsible, person to traditional rules. We will have the owner of the vehicle that will be responsible, person to traditional rules in most jurisdictions that do hold the owner of the vehicle responsible irrespective of the fact that he's driving or not. Then we'll have the product liability rules that will apply to the manufacturer of the vehicle, because we consider a fully autonomous or partially autonomous vehicle, the vehicle itself will drive under certain conditions, and therefore the producer might be held responsible for that crash. And then we'll have the infrastructure manager, so smart vehicles will be connected to the infrastructure, and so there will be somebody managing the infrastructure, and then there will be somebody that is responsible for the connection. So for each one of the vehicles, we'll have 5 potentially responsible parties for that one accident, and understanding which one among those 5 persons actually did cause the relevant element that led to the accident in the ultimate place might not be obvious. You might argue that the accident was caused by a malfunctioning in the connection between the vehicle and the smart road. You might deem that it was a mistake of the smart road that provided the vehicle with the wrong piece of information, like the red light being green instead of red. Or you might deem that the accident was due to the erratic behavior of the human driver, if the human driver was driving, or of the system, if the system was driving, or even of the human being deciding to leave the driving function to the vehicle under conditions where it would have been advisable for the human being to maintain control over the vehicle himself, for instance due to excessive traffic conditions, or the other way around. You might hold the vehicle responsible because it prompted the human being to resume control when it was too late, and the human being could not reasonably be expected to be capable of intervening sufficiently well. So it is indeed a problem apportioning liability between all these multiple potential parties, and that could cause really relevant and really expensive litigation for even the simplest of accidents. So the European Commission identified a number of concerns, a number of risks, which I like. This is my personal categorization to summarize as follows. And actually, in this, I also deviate from some of the concerns the European Commission has identified. The first concern that I have identified is of a methodological nature. If you regulate, and this is indeed one of my greatest criticisms to the emerging regulatory framework, AI is currently being regulated as if it was one single thing, but there are many different forms of artificial intelligence systems that are extremely diverse one from the other. So methodologically, having a horizontal approach to regulation in the attempt of simplifying the system will give rise to relevant concern, and we'll get back to that in a moment. At the same time, what I have just described, the complexity of apportionment, there are accidents that could theoretically be caused by a multiplicity of different factors, and tracking down in each one of them and understanding which one of the factors is the one that led to the accident and caused harm is anything but obvious, and it could be extremely expensive. And this leads us to the third element of criticality, which is a high cost of litigation and the informational asymmetry between the parties. So any reform should be addressing at least these 3 points directly. With respect to the latter, I really want to stress, in the perspective of manufacturers and those developing technology, that if litigation is very expensive, and if there is a lot of informational asymmetry between the producer and the user feels that should something go wrong, he will not be able to recover damages from the producer, that will create a very strong negative incentive towards the uptake of the technology. With a colleague of mine, we wrote an article where we have applying this reasoning to driverless vehicles, and we have demonstrated that if we leave things as they are as of today, there will be a very strong negative incentive for people to purchase autonomous vehicles, or increasingly autonomous vehicles, even if not fully autonomous vehicles, over traditional ones, because they'll be facing much more liability than if they were purchasing a traditional vehicle. And therefore, it will make sense for a human being to purchase an autonomous vehicle or an increasingly autonomous vehicle only at the moment when that vehicle largely exceeds the capacities of a normal human driver to perform on public road and driving in public roads. And this will delay innovation radically. So liability rules have a direct impact on the speed at which innovation can penetrate the market. So what are the regulatory efforts emerging at European level? There are at least 3 pieces of legislation that need to be taken into account. The so-called AI Act, the reform of the Product Liability Directive, and the AI Liability Directive. The AI Act is supposed to be a very broad piece of legislation that applies across the entire spectrum of AI products, AI systems. The other 2 pieces of legislation are entirely dedicated to liability, to civil liability. But what is the European Union trying to do? The European Union is trying to pursue the so-called Brussels effect. What is the Brussels effect? Well, the Brussels effect is the capacity of the European Union to influence all other countries, all other markets beyond its own borders by providing regulation, by providing legislation that all companies, all business players interested in doing business within Europe and with European citizens will have to abide by, thence forcing them to comply with fundamental principles of EU legislation. This has already been observed with the GDPR, the General Data Privacy Regulation. The GDPR is a very famous piece of legislation that, despite being a European piece of legislation, is capable of influencing companies beyond European borders, and has become the benchmark that other countries that are non-European countries have adopted or are considering adopting in order to avoid the complexity of multiple and double standards. So the Brussels effect could, in fact, allow the European Union, if it were indeed, as it is today, the first one attempting to regulate artificial intelligence, to set the benchmark for the regulation of AI and influence the functioning of other legal systems and other markets. So with respect to civil liability, which is a subsection of the whole regulation of artificial intelligence. What do the current proposal bring about? What are the principles that they are trying to put forth? The idea is that of attempting to reduce litigation, attempting to reduce litigation costs, ensuring prompt compensation to potential victims, and force the internalization of risks in a risk management perspective. Those should be and are, to some extent, the purposes of the current reform being conceived for AI-based system and advanced technologies more broadly, in particular with respect to artificial intelligence. So, as anticipated, the AI Act is a very large piece of legislation. It's a regulation. I did not stress this point. The Product Liability Directive is a directive. Directives are pieces of legislation adopted at European level that require each and every member state to enact them by adopting dedicated legislation within their legal ordering. Directives, for these reasons, allow for a great degree of variation across member states. There is less uniformity when member states need to enact a directive because each one of them will abide by the same principles but could choose slightly different legislative solutions, whereas a regulation is immediately applicable as it is written in all member states. The AI Act is indeed a regulation, unlike the Product Liability Directive. It was presented on April 21st, 2021. It's not yet enacted. There was a vote by the European Parliament in June, last June. And it's very likely that it will be approved before the end of 2023. And it's very likely that before entering into force, it will allow for 2 years' time, during which companies primarily will be allowed to conceive ways to comply with these emerging pieces of legislation. The AI Act is very complex, and analyzing it would require much time. But as per what matters to us, namely liability, we shall focus on the definition of artificial intelligence system. Indeed, AI systems are defined by the Article 3 of the AI Act as software that is developed with one or more of the techniques and approaches listed in Annex 1 and can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. So we acknowledge the fact that AI systems are not strongly autonomous because they pursue objectives developed by human beings, identified by human beings. They can be weakly autonomous in as much as they provide outputs in the form of context, predictions, and recommendations. But they are weakly autonomous, not strongly autonomous. And at the same time, they have to be developed according to one of the techniques listed in Annex 1 that you can see on the bottom right corner of your slide. And I don't know if you're experts in programming techniques, but basically those listed are all sorts of programming techniques. So what is the consequence? The consequence is that anything can be deemed and will be deemed for the purposes of the AI Act an AI system, and ever more so. Because AI is a moving target, because AI is pervasive, and we'll have AI in each and every domain of our life. So my toothbrush is indeed an AI system because it has sensors that allow it to sense the way I brush the teeth in the different parts of my mouth and provides me advice on how to improve my brushing technique. My camera has an AI system that is used for autofocus. My cell phone has an AI system, and they all qualify as consumer products. The technology behind these things is all quite different, despite being generally labeled as AI. But it's even more different from the technology behind a language model used by personal assistant, Alexa and the like. Those language models are capable of understanding human natural language, in particular through clouds, mechanisms, and services. Indeed, they function only if they are connected to the internet. And despite being used in a similar domain in the field of consumer products, technologically speaking, they're very different from toothbrushes and cameras. language models are also behind much more sophisticated systems such as IBM Watson or ChatGPT. Those are language models that can understand human natural language and elaborate very complex data, articles and information that is written in books and online sources, and provide complex answers. So a technology which is very similar to that that is adopted by personal assistants, and yet with very different uses and also very different implications. Alexa does not give rise to the same concerns that ChatGPT does. And AI is also used in fintech and, for instance, high-frequency trading. And there are many uses of AI in fintech that could be deemed problematic, that are based on technologies that are entirely different from Watson, Alexa, toothbrushes, and cameras. And however, are also used in domains that are typically kept entirely separate. Capital markets are typically separately regulated from anything else because of the specific concerns and needs they give rise to. So we could make a longer list. We could take into account all sorts of robotics application. We could take into account robotic prosthesis, a robotic arm or leg, an exoskeleton. We could take into account a driverless car. We could take into account surgical robots. All these applications would fall under the definition of AI system, and yet they are so different one from the other and give rise to very different concerns. And as of today, would fall under different branches of existing regulation in at the national and European level. And I'm not so certain, I'm not so persuaded that treating them the same and regulating them all together would make much sense at all. Imagine that even when we discuss liability, we have separate liability rules for medical practitioners and intermediaries in the capital markets, and car drivers and car owners, and consumers and consumer products. So why should we regulate all these things unitarily? I believe this approach, this horizontal approach the European Union is maintaining, is not so good of an idea. The horizontal approach has been characterized in the Probability Directive as well, and is probably one of the reasons why this piece of legislation didn't function so well up until today. The reason why so few cases were litigated by applying this piece of dedicated legislation, and few cases clustered in very specific domains with potentially very high interests at stake, which will not be the case for the most part with advanced technologies and AI-based system altogether. But the Liability Directive is one of the pieces of legislation that the current Commission is trying to reform to adapt it to the challenges brought about by artificial intelligence. And the first aspect, we said it already a couple of times. The definition of product will be expanded so as to clearly include also software and therefore artificial intelligence, but not just that. Many other things, potentially even blockchain, could fall under the notion of products for the sake of the Probability Directive. This will be a huge change in the current regulatory framework, something that anyone interested in developing or applying or using these technologies will have to take into account necessarily. So the second aspect is that the effectiveness of the product will be derived also from the lack of updates that should and could have been developed by the manufacturer, so that are under the manufacturer's control, as well as depending on the failure to provide and to address potential cybersecurity vulnerabilities in the system. But it is also clearly stated that the effectiveness may depend on foreseeable misuse, what was up until today debated by courts, getting to different conclusions in different member states in different moments in time. So the chair that I stand upon that breaks, that would be the foreseeable misuse example. And also, it introduces liability for those cases where the product will be refurbished and placed back onto the market, and also when it will develop over time and improve over time and learn over time. Damages will also include harm to psychological health and loss or corruption of data. The first one in particular was already, as of today, acknowledged by many courts across Europe, but now it will be clearly regulated in this sense. But what is most interesting is the emerging proposal for an AI liability directive. So a piece of legislation, again, a directive, so a piece of legislation that will have to be implemented at national level through the adoption of different pieces of legislation at national level that is entirely dedicated to artificial intelligence. Well, this piece of legislation, the AI liability directive, is intended to apply only to high-risk system, which is systems that are considered to be high risk for the purposes of the AI Act. So here there is a coordination and coherence with the AI Act. And the systems that are considered to be high risk for the AI Act are those referred to by Article 3 and in particular, Article 6 and Annex 3 of the AI Act. And they are typically AI systems that are to be used as a safety component of a product, or AI systems that are supposed to undergo a third-party conformity assessment in the perspective of putting them onto the market pursuant to one of the fields that are currently regulated by the product safety regulation, and all the AI systems that are listed in Annex 3 that have to do with the most diverse fields, including the medical field, for instance. So AI-based system to be used in the medical practice and in curing individuals. But you can read through the list in Annex 3 and you will see that very many applications will be deemed high risk for the purposes of the AI Act. Thence, only those applications that are deemed to be high risk for the purposes of the AI Act will also be regulated by the AI Liability Directive. So the main aspect the AI Liability Directive attempts to regulate is that of evidence. So what the party needs to show in order to obtain compensation from the potential responsible party, which is the producer, the deployer of the AI system, or anyone that uses it to provide some services, or uses it even for personal reasons. So it does not really interfere with substantive rules. It is intended to work on top of national legislation by interfering with the evidentiary rules of each and every member state legal system. Indeed, Article 3 establishes the possibility for a claimant, for a harmed party, to sue the potential responsible party in order to obtain the necessary evidence to establish their liability. This is what I like to call meta-litigation, like litigation in order to be able to litigate. And this is very complex litigation, potentially extremely expensive and highly problematic. What does the law say? The law says that if you think you were harmed by a high-risk system and you cannot have access to the data and information necessary to establish the liability of the person that offered you the service that is based on the AI system, you might ask the judge for an order that obliges that person, that company, that service provider, to provide you with the necessary piece of evidence. So theoretically speaking, if you want to sue somebody in court and you need to establish their liability, you need to establish the effectiveness of the product, you need to establish the existence of a fault, and you do not have access to the relevant information, you should first try and ask your potential counterparty to offer you that piece of information. And I do not expect many potential counterparties, many potential responsible parties to be willing to comply with such a request. And eventually, if you were refused by your counterparty that piece of information, you could then sue that party in court, not to claim the compensation of your damages, but to request access to the relevant piece of information that you will then need to establish their liability. So we'll have to sue in order to be able to then sue and ask for damage compensation. And what are the conditions that are laid out by Article 3? There is the so-called fumus boni iuris, so a prima facie element that leads the judge to believe that your claim for damages is sound and reasonable. And also, however, the judge will have to take into account the potential consequences of forcing your counterparty to disclose that piece of information, in particular with respect to potential costs and risks of revealing IP protected information and overall costs for the corporation that you are acting against. So the judge will have to weigh and balance the opposing interests of the parties, decide whether the interest of the claimant prevails over the interests of the defendant not to reveal that information. And if he so decides, the judge, that claimant deserves to receive the information, he will issue an order condemning the defendant to reveal the information that the claimant will then be able to use in order to sue and claim compensation of the damage suffered. This is a really complex mechanism. We saw at the very beginning that one of the reasons why we want to reform this piece of legislation is to simplify the current regulatory framework. It is clear that such a norm will make the current regulatory framework even more complex than it actually is. Moreover, one could ask whether the European Commission has ever heard of the so-called information overload. Information overload is a phenomenon that is well studied in the literature, in particular also law and economics literature, and says that if you want to hide some relevant information, you can hide it in plain sight by providing the person that you are providing that information to with an excessive amount of information, making it extremely hard for the persons to isolate and identify the portion of information that is actually relevant for him. And that is the case when you have to sign a banking contract. If you have to sign a banking contract, you'll be overloaded with an amount of information that doesn't really allow you to go through the entire contract and understand all the essential elements of that agreement. So, and moreover, not very often people do have the time and competence to understand the complexity of a certain piece of information. So this is the general principle, but let's try. Even if I knew, even if I were given the details of the functioning of the autonomous driving system of the most sophisticated car existing on the market, how would I be able to make sense of that piece of information and identify what actually worked in the wrong way and led to causing the accident? That would be very, 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 very hard to process and very hard to identify and very costly, most likely, me as a claimant would have to resort to the help of a sophisticated expert that would be extremely costly and would therefore discourage my suing in the very first place. But even more problematic is Article 4 of the proposed AI Liability Directive, whereby it says that causation is presumed if fault is established. This seems to be a subtlety in a legal perspective, but it actually is not, because typically speaking, you can only establish somebody's fault once you have before established that the given consequence is, the given effect, the damage suffered in this very case, is the consequence of the agent's action. An agent can only be at fault once you have already established that what he did actually caused the damage. Otherwise, he might not be deemed at fault. But here the European Commission is like saying that causation is presumed if fault is established, meaning that fault has to be understood as something actually quite objective and basically understood as the failure to comply with a very general duty of care or a very general standard of conduct. But this creates a lot of uncertainty within the system about what actually is the grounds liability and what is the true standard of liability that is applicable as a consequence of the enactment of this piece of legislation. So what other concerns seem to be emerging if we take into account the Product Liability Directive and the AI Liability Directive together, the Product Liability Directive in its proposed reform as well as in its original formulation? Well, because all of these pieces of legislation are directives and not regulations, unlike the AI Act, we are to expect fragmentation due to minimal harmonization, meaning that France will develop solutions that will be partly different from Germany and partly different from Italy, and that will profoundly harm the uniformity of the European market in this sense. It also says that the solutions developed do not provide strong incentives to sue and force the internalization of costs, because, for instance, once the information is provided to the claimant pursuant to Article 3 of the AI Liability Directive, that information still needs to be interpreted, and that is very costly and very complex. And we observe that one of the main reasons why we want to reform the current regulatory framework in civil liability is because, as of today, there are excessive costs associated to that depend on the application of existing pieces of legislation, in particular the Product Liability Directive. So today it's already very hard for a claimant to sue the producer of a technologically advanced system based on existing regulation. Thanks to the current reform, it will possibly be even harder. And most likely litigation will be channeled against the weaker defendant and not the truly responsible party. But this will create very negative incentives towards the uptake of technology. If that is the case, we will be witnessing a very confused liability framework. And a liability framework which is not clear will cause a lot of problems. First of all, legal uncertainty will make it hard to calculate and insure risks associated with developing and deploying AI-based technologies. So, potentially speaking, the circumstance that all these liability-related directives will have to be enacted will leave room for some degree of uncertainty and also from some fragmentation at European level that will increase potential costs for companies, leading them to having problems managing the use of these technologies or offering services based on such kind of technologies. This will be based on the fact that there will be divergent decisions and approaches that emerge at European level, because this relevant piece of legislation, as I said, is based on directives and not regulations that are uniformly applied and across all member states. And to some extent, even if it will be quite hard to successfully sue the producer or the user of an AI-based system based on the proposed pieces of legislation, because it will be costly, and in many cases consumers and users of the technology will funnel their litigation towards weaker defendants and the producer or the deployer of the AI-based system. This could in turn reduce the reliance by the normal user, consumer, or even professional user, such as a medical practitioner, on an AI-based system, because they might fear the legal consequences associated with their use. So if a medical practitioner using an AI system will be potentially called in to compensate damage arising from a malfunctioning of the AI system that he is using in his profession, he might decide not to resort to the more advanced technological system and still keep using a more traditional approach. And this could actually discourage the uptake of technology. So a clear set of liability rules, even if in some cases would make it easier for the claimant to obtain compensation from the producer, deployer, operator of the AI-based system, would actually favor those businesses that are trying to bring those technologies to the market, because it would increase the perceived safety and reliance of the human user on those very technologies as well. So indeed, the current regulatory framework is very much evolving. I hope I managed to clarify the fundamental aspects of those rules and systems that are already in place and that are being considered as a reform of the entire framework. And much will be happening in the nearby future. And I believe that all of this is of great interest for somebody that is trying to innovate and bring technology to the market. I encourage you to follow us in our further activities and reach out to us if you have any questions. So thank you for your attention.